We'll go ahead and get started. So, welcome everyone to our AdaptLA workshop on legal dimensions of managed retreat in California. My name is Karina Alvarez. I'm a science research and policy specialist at USC Sea Grant, and I'm really excited for today's workshop. I'll pass it over to Phyllis Griffman, our executive director, just to give a quick welcome to you all today.
Thanks, Karina. I'm Phyllis Griffin. I'm the executive director of USC Sea Grant, and I want to acknowledge Carla Heidelberg, our director, who's here this morning. Um, just a quick word about USC Sea Grant. Sea Grant is a network of 34 programs in coastal Great Lakes and island and Guam. And Sea Grant is dedicated to ensuring that peer-reviewed relevant research gets out to policymakers and decision makers and to stakeholders where it's needed. So unlike other research programs, research that's funded, invested in through the Sea Grant programs don't just go to journals, they go out into the public, and we welcome input into what the research and information needs are, so that we can make wise decisions about our coasts and oceans. The Sea Grant Law Center, which funded Robin Craig's work on legal aspects of sea level rise, is one of the 34 Sea Grant programs. It provides legal research, education, outreach to other Sea Grant programs and to their constituents, including some competitive grant programs, which is how this is funded, in order to help Sea Grant programs address legal issues in their communities. Not many Sea Grant programs have legal expertise on their staffs, and so the Sea Grant Law Center is our primary go-to for legal information and advice. AdaptLA, the sort of under the aegis, this is one of the programs under the aegis of our AdaptLA program, started around 2011 as an attempt by our program to provide assistance and strategic advice to coastal communities to translate coastal communities in Southern California, not only in LA, to translate some of the more complex and technical aspects of sea level rise and climate change models, and to provide information about how to conduct vulnerability assessments, and then what kinds of adaptation methodologies are possible. This is one of our efforts to help people understand this particular aspect of adaptation, which is called managed retreat, even though that might not be the best name for it. And so that's the short version of what we're doing. And I'll turn it back to Karina to start our day.
Awesome. Thank you, Phyllis. Can everybody see that okay? Get a head nod? Great. Okay. So just a few more introductions, housekeeping items. We want to start with a quick land acknowledgement of the space where a lot of us live, recreate, and do our work. Although I acknowledge that we have a lot of people from a lot of different places today. We'll focus on Southern California because that's where USC Sea Grant is based. So the Southern California Bight is located on the unceded sacred and traditional lands of the Tongva, Ajashaman, and Chumash nations, who are the first native peoples, and they are the original stewards of this land as well as continuing in this role today. And so we really want to keep that in mind, particularly as we think about movement of people and how much choice there is in those processes. A quick review on what we hope to get out of today. We want to first provide some legal expertise from Dr. Robin Craig on topics relevant to coastal adaptation planning, particularly, as you all know, managed retreat. We want to provide some resources for future opportunities for better understanding this, and I'll share more about that later today. We want to think about these strategies ourselves using a legal lens. So we kind of want to practice some of what we learned today. And then we want to identify legal challenges going forward. After we hear all of this amazing work that Robin's done, we want to think about what do we need now going forward to operationalize and further advance adaptation planning. The other thing I want to note is just a few community norms. As we know, this is a really challenging, complex topic. And so we just ask that all of the participants here today model some norms to make this as productive and fun of a meeting as possible. So we ask that everybody listen and participate with respect for the diversity of perspectives today. We want to ensure that all of the comments, both verbal and written, are constructive to the purposes of this workshop. And we ask that you participate authentically and be fully present by managing your technology respectfully. I know it's a good chunk of time that you're giving to us this morning, and so please feel free to kind of shake your legs out, do what you have to do. Um, but we ask that ultimately you can be as present as possible. And the last thing I'll note is if during the presentation everybody can keep their their mics muted, just so we can make sure we hear Robin's presentation. Like I said, the presentation will be recorded, but the breakouts will not. And so we hope that that facilitates really honest and robust conversation at the end of the day for those that did register for that portion of the workshop. And lastly, before we jump in, I just want to do a quick run through of the agenda, which you've all seen. Um, but we'll have a presentation from Robin for the first hour and 20 minutes, and then we have a good chunk of time for a Q&A. And that can even run a little bit into the break if we need to. But for those of you that didn't register for the breakout session, you'll be done after the Q&A at around 10:50. But those that did register for the breakout session, after the Q&A, you get a little bit of a break, and then you can come back for this last hour. And if anybody needs the agenda in front of them, I will link that shortly in the chat. So without further ado, I will introduce Robin Craig. So Dr. Robin Kundis Craig is the Robert C. Packard Trustee Chair in Law at the USC Gould School of Law, where she teaches environmental law, water law, ocean and coastal law, toxic torts, civil procedure, and administrative law. Craig specializes in all things water, including climate change adaptation in the water sector, the food water energy nexus, water quality and water allocation law, marine protected areas and marine spatial planning, and the intersection of freshwater and ocean and coastal law. Craig received her BA from Pomona College in Claremont, California, her MA in Writing About Science from Johns Hopkins University, and her PhD in English Literature, specializing in how the English Romantic poets used contemporary science to explain social change from the University of California, Santa Barbara, and her JD summa cum laude with a certificate in environmental law from the Lewis and Clark School of Law. Robin Craig is also the author of our brand new community guidebook to coastal adaptation planning, legal issues in California. We will be sure to share this resource in our post-workshop email with a few other resources, as well as with the recording. And so the presentation today will largely come from the work that built this guidebook. And so we're really, really excited to have Robin and so grateful for her time this morning. And without further ado, I will pass it over to her.
All right. Well, thank you everyone for being here. And I will get this going. Very interesting to see people from all over the place. So I'm going to go through what might seem like a sort of random collection of legal issues, but they all bear on uh, managed retreat. And as Karina mentioned, I'm framing this in terms of managed retreat versus unmanaged retreat. And we'll get to that in a second. But some legal things to think about when you think about managed retreat. All right. So today's topics, where we're going to go, I'm going to start with some basics about what it means to be a coastal property owner in most states and in California. To begin with, it's a dynamic zone. It always has been. And sea level rise, if you're experiencing sea level rise or severe storms or both, there are just some basic ownership rules of living in the coast that can facilitate managed retreat or will be part of unmanaged retreat in areas experiencing both of these phenomena. All right, and then like I said, I'm going to talk about managed retreat and maybe reframing the issue a little bit. Then I'm going to talk about the National Flood Insurance Program. This is a program that has actually facilitated people staying in dangerous zones. Historically, it's undergone some changes as a result of hurricanes in the east. California is in a particularly interesting position with respect to the National Flood Insurance Program. And it's one of the legal regimes where Congress really is thinking about changing it and changing the incentive structures it has presented in the decades of its existence. Then I'll talk about what is the first signs of unmanaged retreat, which is coastal infrastructure abandonment. And this is a little haphazard, but states are starting to deal with what happens when municipalities make the decision that it's no longer worth it financially to repair, rebuild, maintain coastal infrastructure that is repeatedly getting damaged. And then the elephant in the room, as I called it on the outline, takings liability. What are some of the things, considerations of constitutional takings claims, and what are some of the exceptions to those that might become increasingly important in dealing with managed retreat? All right, so just changes in ownership on the coastal in the coastal zone. Uh, if you're in an area experiencing sea level rise and worsening storms, coastal ownership is going to change regardless of whether there's any retreat whatsoever, managed or otherwise. And so in most states, the dividing line between private ownership and public ownership is the mean high tide line. There's some variations in the East. Some states use different lines, but it's usually the mean high tide line. And at that point, below that line, it's owned by the state. So the state owns the submerged lands, usually out to 3 miles in the Gulf of Mexico. Florida and Texas have a little bit more. But that is state-owned property. State sovereign submerged lands is how it's often referred to. And so there's not just one owner in the coastal zone, there are two. And as that mean high tide line shifts, the state, the public, is acquiring ownership of either less or losing ownership if sea level is actually retreating, or gaining ownership if sea level is rising. And that's important to remember, because a lot of the conversations about the coastal zone assume that the private landowner is the only one to worry about. There's some interesting cases out of Washington involving the other owner actually being a tribe, not the state, and that makes concrete the fact that there is a second owner out there. So how do we determine the boundary in California? The California Civil Code defines the boundary of tidelands as the ordinary high water mark. It's the California State Lands Commission that has exclusive jurisdiction over ungranted tide and submerged lands. There were a fair amount of tidelands, particularly in the San Francisco Bay Area, that got granted away before California got serious about keeping them. But nevertheless, the ungranted ones are under the authority of the State Lands Commission. And it's the commission's the recognized authority for determining the location of the ordinary high water mark in California. Now, typically, the commission uses NOAA's calculations and data, which are based on the average over 19 years. That's the normal way of determining the mean high tide line, is over 19 years, which sounds bizarre, but it's tied to the lunar cycle, which is what determines the tides. So if you care to play around with NOAA's data, you can get readouts like this for Los Angeles. And pretty much every value you would want to know along the coast is there. The mean higher high water, which is important in some states. The mean high water, the mean tide level, that's the average of all tides, mean sea level, and on it goes. But if you look at the diagram on the right, what line you pick matters, because there are significant differences between mean high water, mean tide line, mean higher high water, which is the highest mark up there, mean low water, mean lowest low water, average of the lowest tides, and where you go. So some areas of the country, these lines actually don't change all that much. Along the Gulf Coast, for example, there's not a whole lot of difference between mean high and mean low tide, and so these lines tend to cluster together. But in different coasts of the United States, Maine is probably one of the more extremes. Which line you pick can make a real difference as to where that border is between private property and public property. All right, but that boundary moves. It moves seasonally. It moves over that 19-year cycle progressively. For title purposes, who owns what? It's that longer period of time. It's more gradual. But as you can see, even seasonally along the California coast, where the tides are going can change from month to month, and how much beach there is can change from month to month. So it's a very dynamic system. Like I said, for tidal purposes, what we're worried about usually is that 19-year average and the progressive average over time. So effective rising and falling seas, if the boundary has not been fixed, and there are some procedures in California for fixing the boundaries, it hasn't happened a lot that I can determine. But you start with where the mean high tide line is. If you're in an area of California where the land is actually rising, sea is retreating, there are some of those. The private landowners eventually are going to acquire more property as the sea retreats. But for a lot of California and a lot of the country, sea level is rising, meaning progressively that boundary line will move inland. And a map I have shown before at these things, but it's an interesting map to see. Red is where sea level is rising in California. Blue is where sea level is falling in California. Or I got that backwards. Sorry. Blue is where sea level is rising. Red is where sea level is falling. So we do have both kinds of areas in California, and that will make a difference to how those areas think about coastal retreat and what's actually going on with the property lines. All right. Along with sea level rise and climate change, you get worsening storms. This has a more dramatic impact on changing the coast and can rather quickly change where what the coastal zone looks like and where that mean high tide line might be as a practical matter. So this is Capitola in January of last year being inundated by a storm. And so this brings up the second part of just background property law along the coast that I want to mention, which is that municipalities and the state almost always, and they certainly do in California, have the authority to condemn properties that have become unsafe. And this has happened in California in various places, particularly after these bad coastal storms that make properties actually unsafe for habitation. And so these were some cliffside residences that were condemned in Pacifica because the cliff had just become too unstable. They were hanging out over the edge. These were not fit for human habitation. But again, the legal point is that municipalities and the states retain that authority that when a property has become so deteriorated or so unstable that it should not be used as particularly homes, it can go in and condemn those properties. And that is another form of ad hoc coastal retreat. So local authority in California to deal with dangerous properties. The California Coastal Act explicitly preserves cities and counties' authority to declare, prohibit, and abate nuisances. And municipalities do not need a coastal development permit to abate coastal nuisances or order demolition of unsafe and substandard conditions. There are other procedures they have to follow before they do this, but they don't have to get a permit under the Coastal Act. And this abatement authority includes the authority to demolish buildings and other infrastructure that have become unsafe or that pose an imminent hazard with no compensation owed. So this is a public safety measure. It's abating a nuisance. That is one of the exceptions to takings doctrine that I will get to, but no compensation is owed so long as the city or county follows the required procedures. So again, I just want to mention that without doing anything else, these two basic aspects of coastal property law remain in effect. And as we see increasingly worse storms coming in and making structures unstable, we are going to be seeing a form of retreat as they cross over that nuisance line and local authorities continue to condemn them. All right, so getting into managed retreat. The normal framing of the coastal retreat discussion is basically not to invoke the clash, but should we stay or should we go? And so the discussion tends to revolve around what structures do we need to remain in place? Do we want to invest in gray infrastructure, seawalls? Do we want to think about green infrastructure? Do we need to think about anything else? Shall we raise buildings? Or do we think about leaving the coast entirely? And in some places, that is the right discussion, because what is happening with sea level rise and storms varies considerably from place to place. And there are many options that municipalities along coast can consider. Some of these may be far-fetched, but all of them are being thought about somewhere. So you can consolidate and move inland instead of having bigger properties. You bring properties closer together and leave some space out by the ocean. You can elevate. This is very popular in Florida, where building standards along the coast now require significant elevation, so properties on stilts. There are some places that are experimenting with floating parts of their cities as one way to adapt rather than retreat. Of course, we've got the walled resist. Now, if you're in an area with experiencing significant sea level rise, significant subsidence, and/or significant storms, eventually those will fail. They always do. But nevertheless, under the right circumstances, it might be a good stopgap. And then hybrid approaches. So there's, like I said, there's a lot of options, and we need a lot of options because what a particular coastal community is facing could be very different. But I'm going to focus on those places where sea level rise and storms are both pretty bad. Where sea level rise is significant and storms are getting more frequent and worse. And there, the framing may more profitably revolve around, do you want unmanaged retreat versus does managed retreat sound like a better plan? So with unmanaged retreat, you're getting that haphazard, things happen after storms, properties get condemned, we've got a lot of wreckage left behind, we have progressive deterioration of quality of life, we have loss of investment values, and we have the problem of who gets stuck holding the bag, who's there last, that dealing with a community that's slowly but surely been falling apart because of these combined forces. At that point, managed retreat might sound like a better plan. You can use predetermined triggers for staged abandonment. You can start redirecting incentives like insurance, which is one reason I'm going to talk about the National Flood Insurance Program, toward relocation. So what does managed retreat look like? For most people, it's kind of a consolidated opinion on what managed retreat should look like. You want to, in the calm of a planning stage, not after a major storm or not certainly in the midst of a major storm, come up with predetermined triggers for moving off the immediate coast, including loss of municipal and state services. So what happens that says, hey, it's time to start moving off the immediate coast? Is it the storm that finally breaks through or overtops the seawall? Is it uh sea level rise has hit a certain point overall? Is it the erosion of a critical cliff? Whatever that trigger happens to be for that community, it's like, okay, we've determined these in a calm state of mind. Now, as they happen, we know we're going to take the next step. So having that plan in place. Couple that with incentives for private landowners to leave earlier, and insurance could be a big one. To say, hey, you know, rather than pay you to rebuild, we're going to pay you to move, might be one way of changing insurance. You need to have funds for the infrastructure removal. What no one wants is a coast that's left with a whole bunch of pipes sticking out, concrete, rebar. You know, we want to be uninfrastructuring the coast, taking things out as retreat is occurring, and that takes money. Think about repurposing the coast when possible. A coastal environment is even subject to storms and sea level rise is likely to be useful for something. Aquaculture might be one thing, ecosystem restoration, resilience building. Again, taking the forethought to think about we're not just abandoning it with all the human detritus we're leaving behind, but leaving human habitation in favor of something else that might help overall climate adaptation or food security or ecosystem restoration or whatever. Then, you know, where are the people going to go? And this again is going to be dependent on local circumstances and individual preferences. It could be possible in some locations if you've got empty land behind the current municipalities to simply shift inland, or probably more leapfrog inland. People closest to the coast will go farthest inland. But that's not always possible if you've got back-to-back development, as is true in much of California. So another possibility is to go somewhere else as a community. That's being explored most extensively right now with relocation of Native American communities in Louisiana and Native Alaskan communities in Alaska, is just kind of move the whole community somewhere else. Or, you know, just disperse and go elsewhere into the general population. And that was effectively what happened after Katrina in New Orleans. There's a lot of people who still have not moved back to New Orleans who used to live there. They just sort of dispersed into the rest of the general population. Again, going to be dependent on what your actual physical circumstances are and what the community desires might be. All right, so some legal incentives that are out there and starting to crop up that could affect managed retreat. The big one is the National Flood Insurance Program, which has created a lot of perverse incentives over time. Now is in financial difficulty, and Congress has been trying for close to 7 years now to try and fix the National Flood Insurance Program. With some basics, if you're not familiar with NFIP, it was established in 1968, 3 years after Hurricane Betsy flooded Florida and Louisiana. Congress, up until that point, was in the position of only being able to provide disaster relief to communities that were hurt by these floods. And so it said, hey, we would really like to be able to intervene up front. So what the National Flood Insurance Program was designed to do was relieve a market failure. private insurance companies were leaving flood zones. They're still leaving flood zones. But private insurance companies were leaving flood zones, affordable insurance for people subject to flooding, primarily along the Mississippi is what Congress had in mind when it enacted the act. Had people who lived along the historic Mississippi River who experienced the flood of 1927 were having real problems getting any private insurance whatsoever. So Congress was going to step in and provide that insurance. And as I mentioned, you know, provide a shift away from just being able to provide disaster relief, be able to do things a little more proactively. And then finally, and somewhat perversely, Congress' goal in 1968 was to actually move people out of floodplains. If you know anything about the National Flood Insurance Program, you know it's had precisely the opposite effect, which is to make people living in floodplains financially viable. But that's not what Congress intended from the outset. It didn't design its system very well, but it did really want to move people out of floodplains. The agency in charge of the NFIP is the Federal Emergency Management Agency, or FEMA. It administers that program. There are roughly 5 million policies in effect. It fluctuates a bit over time, but about 5 million policies in effect. And between 1978 and 2005, and I'm stopping at 2005 for a reason, that's when hurricanes started to dominate the National Flood Insurance Program. But before hurricanes became the major force, the NFIP had paid out about 5.5 billion to 30,000 properties that FEMA classifies as severe repetitive loss properties. So these are properties that have been flooded and recompensed about 5 times on average. So these are the properties that everyone worries about under the NFIP, that we are paying people repeatedly to rebuild in an established dangerous place to be building. All right. How the National Flood Insurance Program works is it got rid of actuarial based insurance rates. So insurance rates are set to be roughly the same for everybody. That's been adjusted a little bit, but people in areas prone to severe flooding are not paying anywhere close to actuarial rates. And so you know, a normal insurance company, if you're subject to flooding every 10 years, you would be paying $25,000 in flood insurance every year. That's why the insurance companies pulled out of the market. That's why Congress stepped in. So Congress's plan for keeping things affordable was basically everyone at some risk of flooding would pay roughly the same rate, which means there's some heavy subsidizing going on of people who are at minimal risk of flooding are actually subsidizing the people who are at severe risk of flooding. So this is just a map of the last time there was a great study done on the National Flood Insurance Program in 2015 of the policies in force. California is significant, but not by far the most number of policies in force. That honor goes to Florida. It's got almost 4 times the next largest state of Texas. Louisiana is high as well. So California is in the mix, but not at the top of number of policies in force. This is another way of looking at it as number of policies per 10,000 people or 10,000 houses, sorry. And again, Louisiana, Florida, New Jersey now pops up near the top of the list if you're looking at policies in force that way. Another way of looking at the total NFIP policies by county. Now, this is a little skewed if your counties are more heavily, coastal counties are more heavily settled as they are in California. It makes it look like things are a little bit worse than maybe they are, but nevertheless, you can see where the policies are. All right, this is the important part of what's been happening to the National Flood Insurance Program since 2005, which is that a program that was actually designed for river flooding. It was sparked by a hurricane, but it was designed for river flooding, is actually financially stable for river flooding. So those inland counties, the 2,700 inland counties, what you're worried about there is river flooding. Mississippi, Missouri River primarily flooding. And as you can see, the premiums that come in have just a little bit of surplus, but they cover the losses. What doesn't work is using the National Flood Insurance Program on the coast. So there's 284 coastal counties. First thing you notice is the premiums are higher for coastal insurance. Like I said, NFIP started adjusting, but so are the expected costs. And the coastal county national flood insurance policies have been running at a deficit since 2005. What happened in 2005? Hurricane Katrina and a bunch of other really bad hurricanes. So the deficit in the National Flood Insurance Program has really been driven by coastal counties and those major hurricane seasons. So 2005, 2012, 2017, and now it seems like we've been kind of continuously in them, but they required FEMA and the federal government to pay out far more in damages than the premiums that have been taken in, and have put the National Flood Insurance Program into the red zone. So this is another way of looking at the National Flood Insurance Program, and again, it's a program based on some properties subsidizing others. And what I just want to point out is California is a state, it benefits from the National Flood Insurance Program. There are definitely property owners that have benefited from it. But on the whole, California is what's known as a donor state. California, on the whole, pays more in premiums into the National Flood Insurance Program than it recovers in payments. And so property owners in California, and actually many places on the West Coast, are subsidizing those hurricane losses in the East. This has not gone unnoticed by the California legislature, as with other states have considered pulling out of the National Flood Insurance Program. How that would legally happen is still possibly being worked out. But it's part of the economics of the National Flood Insurance Program that who pays and who gets is not even roughly equal across the country. All right, and like I said, this is what FEMA worries about most, and now Congress is worrying about most, is those repetitive lost properties. Repetitive lost properties, exactly what they sound like: people who have had their homes destroyed by flooding more than once. National Flood Insurance Program, as of 2013, had paid out $9 billion to these repetitive lost properties. That's just 1.3% of the policies that are out there, but 25% of the payments. So those repetitive loss properties skew the economics of the National Flood Insurance Program. As you can see, most of them are along the Gulf Coast, and after Hurricane Sandy, this is these stats reflect Hurricane Sandy. You can see that New Jersey and New York and the Northeast picked up more as well. In contrast, again, the West Coast has some, but not nearly as many as in those other areas. All right, so evaluating the National Flood Insurance Program, I love this quote from Arnold in 2011. The National Flood Insurance Program is an actuarial joke. It would be like having a federal automobile insurance company that only insured teenage boys who drink and drive. By definition, the properties covered by the program are doomed to be flooded, damaged, and even destroyed, not just once, but again and again. So my saying is, if private insurance companies can't figure out how to make a profit after in an insurance market, unlikely the government is going to figure it out in a better way, and so we find ourselves with a national flood insurance program in the red. Now, like I said, people in California do benefit from it, even though California as a whole is a donor state. Certainly over the life of the National Flood Insurance Program, and this is from the FEMA website, $60 million has come back into just Los Angeles, over 4,000 claims having been paid. So it's not that California doesn't benefit from it, or at least particular property owners in California don't benefit from this program, but overall the state is a donor state. All right, a national flood insurance program for managed retreat. If you are really thinking about using flood insurance as a way to encourage orderly retreat from the coast, you would revise the coastal risk assessment projections. And Hurricane Harvey proved this more than anything else, that there are areas of low probability of a major coastal storm, but potentially very high damage if one happens to hit. And it would be financially prudent to include those properties in the National Flood Insurance Pool. So there were a lot of properties in Texas when Hurricane Harvey hit that were not eligible for national flood insurance, did not have flood insurance because the hurricane had never done what Hurricane Harvey did. So identifying those low probability properties could be beneficial. The program needs to do a better job of building in sea level rise projection and storm surge into the flood maps and risk assessments. FEMA has been slow to do so because the way the statute has been set up is to be backward looking rather than forward looking. So flood risk was assessed, and there were some legal drivers for this, assessed on the basis of what had happened in the past rather than what people could reasonably project would happen in the future. And that needs to change with increasing premiums in places where the sea is rising. There is a move, and this is part of what Congress is considering, to condition post-disaster relief availability, at least in part, on the property owner having flood insurance and taking mitigation measures on the property. So not leaving your property in its most vulnerable state, maybe putting it on stilts, putting in elevation, taking critical things like electrical systems off of the ground floor, whatever. There are a lot of ways to build in some protections against properties, or protection against flood into properties. And it really needs a policy to eliminate those repetitive lost properties. These are the properties that are signaling that they need to be retreated from. I have advocated an article that once the government has paid for your property twice, it has satisfied any need to pay you for the market value of your property under the Constitution. And on the second full payout, the government should be deemed the owner of that property. You get the payout, you've got money to move somewhere else, but we're done insuring that property. It's now in government ownership, and we can do something else with it. So that's one way. There are other ways to think about it, but like I said, if you talking in terms of orderly managed retreat as opposed to unmanaged retreat, those are the properties that the first focus should go to. So where is the National Flood Insurance Program now? The last multi-year reauthorization expired on September 30th, 2017. These tended to be 5 years, but it was the one thing you could count on Congress doing, no matter how fractured it was, is every time the National Flood Insurance Program came up, Congress would reauthorize it for another 5 years. That stopped in 2017, that third hurricane season that bankrupted the program. Congress stopped reauthorizing it for multiple years. So that expired on September 30th. The National Flood Insurance Program has continued to exist only because Congress keeps extending it for 3 to 6 month chunks at a time. Congress has actually let it lapse a couple of times, but then gone back retroactively and reinstated people's coverage. So there's now been 25 of these short-term extensions, while Congress has tried multiple times to rewrite, amend, reconfigure, completely overhaul, depending on what bill you're looking at, the National Flood Insurance Program. So the latest extension is going to expire on February 2nd, 2024. I expect that there will be another short-term extension of it. There's no legislation that I'm aware of that's poised to pass between now and February 2nd. The National Association of Realtors has estimated that this has real effects on property sales. So this is part of unmanaged retreat, particularly in areas prone to flooding like the coast. They claim, now it's probably inflated a bit, but it's still interesting to hear, might impact about 1,300 property sales a day, 40,000 closings a month if Congress lets the National Flood Insurance Program lapse. In the meantime, FEMA has been trying to update where it can. Now, its authorizing legislation hasn't changed, so it's got to kind of work where it has the discretion to work. But on April 1st, 2023, FEMA fully implemented its new pricing approach, which is calls Risk Rating 2.0. This is a start at trying to incorporate more realistic pricing and risk assessment. It gets rid of the flood map methodology, which was completely historically looking. It incorporates new information like the increasing costs of rebuilding a home, flooding frequency, and what kind of flooding you're subject to. Is it a river? Is it storm? Is it the sea coming in? So all of that has started to be incorporated into FEMA's new pricing approach. Again, it doesn't have new legislation, doesn't have quite as much discretion as maybe it would want, but it's starting to try and to take a new approach. But insurance rates increases are capped at 18% per year. That was in reaction to the first time FEMA tried to make the insurance rates a little more realistic. Some property owners, particularly in Florida, were suddenly getting hit with NFIP bills that were 4 or 5 times what they had previously been paying, and getting out of the affordable range. So there's now a cap of 18% per year. All right, moving on, and municipalities abandoning infrastructure. So this is the first signs that we are entering into an unmanaged retreat phase in various parts of the country. And what you see is municipalities, as I mentioned, refusing to maintain or repair infrastructure in the coastal zone. That can include roads, it's most common, but also water supplies, sewage lines, and other infrastructure. And the question is, do they have to? So, like I said, coastal communities starting to do this. Repeated and expensive repairs are often the reason, especially if people and businesses are already moving out of the community. But the people who remain often sue, and that's the ongoing legal issue, is whether they have claims and under what circumstances to force their governments to keep the infrastructure in place. So one of the first cases came out of Florida in 2011, Jordan versus St. Johns County. It involved Old Highway A1A, which, as you can see, is right on the coast. Occasionally looks like it's in the water. But after Hurricane Matthew in 2016, St. Johns County decided it wasn't going to maintain this old road anymore. in part because this is what the hurricane did to the road. The road was really chewed up. They basically have to rebuild it from scratch. This wasn't the first time a hurricane had severely damaged old A1A, and St. John's just said, you know, it's not worth it anymore to keep this road up. However, its legal mistake is it failed to follow the formal abandonment procedures that were required under county law for the county to abandon a road. A lot of this is notice to the community and consideration of other options, but it didn't do that. It just decided we're not rebuilding it. So some property owners in a community called Summerhaven sued the county, arguing that it failed to follow its own procedure and that the abandonment constituted an inverse condemnation or a takings, basically. And Florida's 5th District Court of Appeals basically agreed with the landowners, gave the county a couple of outs, but said, you know, the county must provide a reasonable level of maintenance that affords meaningful access to these coastal properties unless or until the county formally abandons the road. So until it went through its own procedures for abandoning a road, it had to keep it reasonably maintained in a way that afforded meaningful access to the relevant community. Next up, we've got Litz versus Maryland Department of the Environment, which came out in 2016. Not coastal, but raises some of the same issues that other coastal properties might. So Litz property had a recreational campground on it. She was next to a lake. And her argument was that the town of Goldsboro had failed to adequately maintain the town's septic system, led to sewage contamination of the lake, costing her $7 million in damages, because obviously no one wants to come to a campground next to a lake that's contaminated with raw sewage. So the Maryland Court of Appeals held that the town and the Maryland Department of the Environment had a duty, an actual legal duty under existing pollution control law and a 1996 judicial decree to manage that sewage and the septic system. And as a result, because they were violating a clear legal duty, Litz had shown, again, a taking of her property, an inverse condemnation of her property. Thus, the court found liability for failure to repair infrastructure in the face of a known danger, and like I said, in a legal mandate to do so, which could be broadened to known dangers from climate change. And here I'm relying on some work done by a colleague of mine named Mark Nevitt, who's got a brilliant article coming out later this year in the Stanford Law Review, all about managed versus unmanaged retreat. So kudos to him, and I recommend that article when it comes out. All right, Louisiana has the primary federal government case in the wake of Hurricane Katrina. Property in New Orleans' 9th Ward sued the federal government for a taking because of the flood damage they experienced during Hurricane Katrina, which you can see here. They allege that a lot of their flooding was because the government failed to maintain the Mississippi River Gulf outlet, a series of canals and levees known as Mr. Go, and that was the primary cause of their damage. So that if that hadn't failed, they wouldn't have flooded or not flooded nearly this badly. And so basic rule kicked in here. The U.S. Court of Appeals for the Federal Circuit rejected the landowner's claims, concluding that the federal government cannot be liable for a taking because of inaction. In the absence of actually violating the law, just failure to act does not give rise to takings liability. All right, and then here in California, relevant case is Areola versus the County of Monterey, which came out in 2002. Monterey County knew the Pajaro River levee project was in danger of failing, failed to take any action. It's actually a complicated set of facts. The California Department of Fish and Game, the maintenance was getting rid of aquatic vegetation for the most part. So the county wanted to dredge, which is simple and relatively inexpensive. The California Department of Fish and Game, local environmental interests didn't want it to be mechanized clearing of the channel. They didn't like when the county then proposed to use herbicides to get rid of the aquatic nuisance growth either. And so as a result, in the face of these immediate protests of trying to keep those channels maintained, Monterey County kind of let the aquatic weeds grow up, and the channels and levees got choked. And the levee failed during a severe rainstorm in 1995, flooding the residents' property. 300 property owners sued, and the California Court of Appeals upheld their tort and inverse condemnation claims, again finding in large part under the relevant statutes are authorizing this project, the Monterey County did have a duty to keep things in repair. Now, this failed again last year. This remains an active issue in California. Again, it's not coastal, but it does raise the prospect that under certain legal conditions, even making decisions for environmental purposes might not be enough to insulate counties and other municipalities from their duties to maintain infrastructure. So some lessons from these cases. We do have that background rule. A government's failure to act generally does not give rise to liability. However, a government's failure to perform a legal duty or follow legally required procedures is the surest path to liability from failure to maintain infrastructure. And some courts seem primed to find liability for failure to act in the face of a known danger. And if the County Monterey case in California is any indication, that willingness may manifest even in the face of conflicting environmental claims that make maintenance and repair difficult. So we'll see how this plays out. But like I said, the point here is we are starting to get the signals from multiple states that in the face of certain flooding challenges, they are more willing to not maintain infrastructure than maintain it. Okay, a better approach, and again here I am borrowing from Mark Nevitt in his forthcoming article. Advance notice and climate disclosures in all property transactions would be a good transitional mechanism if you're trying to engage in managed retreat versus unmanaged retreat. Now, climate disclosures in property sales is highly controversial. It's been raised in several places and is generally opposed, particularly by the real estate community. But it is fair to buyers to warn them that the property they're buying is subject to some climate risk and give them some advance notice that maybe you're not going to be able to be here forever. A systematic withdrawal of government services, again, as opposed to the haphazard withdrawal in response to hurricanes or other flooding events, is to be preferred. Again, if your choice is unmanaged retreat or managed retreat, some planning ahead is a good thing. And then full-scale retreat from the coastal zone when that becomes warranted. All right, our last topic, like I said, the elephant in the room, what has driven a lot of these cases that I've discussed is takings liability. So all constitutions, the U.S. Constitution, every state constitution says that the government cannot take your private property for public use without compensation. Public use is one limitation. It has to be taken for a public use. At the federal level, what counts as a public use is anything that has a public purpose. So it's not that much of a limitation anymore. If you're familiar with the Kelo case and the taking of private houses to build an industrial complex, that got a lot of people upset, but it does illustrate that the public purpose part of the federal constitution doesn't have much teeth. In certain states, it does. But the fact that you have to pay compensation, that is very much enforced at the federal government and state levels. So the 4 types of potentially compensable takings that have been recognized, there are the physical takings. These are the traditional takings. So the government actually takes title to your property or physically uses it for a public purpose. They use part of your property, for example, for a public road or a highway. They take all of your property for a public park. That gets you full compensation. Highest and best use, market value of the property, compensation is required. And the U.S. Supreme Court has made clear that any physical occupation of your property requires payment, even if that payment turns out to be somewhat nominal. So if a government, in that case, the case is called Loretto, if a government requires that property owners put up with cables from cable TV companies, even though it's a minimal use of your property, it still requires compensation. So any physical use or taking title to your property requires compensation. Much more nebulous is regulatory taking. So here what you have is a government regulation that interferes with a property owner's use of the property or reduces its value. These are evaluated under the Penn Central balancing test, which looks at the property owner's reasonable investment-backed expectations, what actually was done to the property, and the government's interest in the regulation. And so this balancing test is not entirely predictable, except to say that the government usually wins. So it strikes fear in the heart of a lot of governments. It actually has impeded governments from doing some things they legally could do because they fear the liability. And of course, litigating these cases is also expensive. But on the whole, when you have what's known as a regulatory taking, the government usually wins. Not always, but usually. Then, at least in federal law, we have what's known as the per se or Lucas taking. The Lucas taking was a coastal case, came out of South Carolina. South Carolina was having some severe beach erosion, and so put in limitations about where building could occur. Mr. Lucas had a property that at that point became practically undevelopable. And so he sued, saying that South Carolina had taken his property and owed him compensation. What's critical legally in that case, because the lawyers didn't know it was going to be critically important to the outcome, they conceded that Lucas had lost all the value of his property, and the Supreme Court jumped on that and said, well, hey, if a regulation takes away all the value of your property, then compensation is owed. No lawyer will ever concede that ever again in a takings case. And so Lucas takings have been very rare. But nevertheless, if a regulation destroys all the economic value of a property, compensation is required. That's going to be really hard to show for almost any piece of property if you actually have to prove that all economic value is lost. Because even if you can't build a home, you can almost always do something with a piece of property, even if it's to have a hot dog stand on the beach. So these are going to be rare. And like I said, it was just because the lawyers conceded something. It turns out they shouldn't have conceded, but nevertheless remains out there as a case. And then finally, you can have state law taking. So you have a choice as a property owner a lot of times. If a state government has acted, you can bring a claim under both the state constitution and the federal constitution. You can pick them. But some states basically just follow federal law. Texas, for example, Texas taking law is almost identical to federal takings law. Some states offer broader protection, and as a result, from state to state, what you can sue about and what will get you compensation can vary a little bit from the federal model. So this is the California Constitution. Property may be taken or damaged, so it's a little bit broader than the federal Constitution, which doesn't include damage, for a public use only when just compensation ascertained by a jury, unless waived, has first been paid to or into court for the owner. So if you're going to condemn property, use eminent domain, pay up front. State and local governments are prohibited from acquiring by eminent domain an owner-occupied residence for the purpose of conveying it to a private person. So the kilo problem I mentioned at the federal level, California has gotten rid of, at least for private residences. However, that limitation doesn't apply if state or local government uses eminent domain to protect public health and safety, preventing serious repeated criminal activity, responding to an emergency, or remedying environmental contamination that poses a threat to public health and safety. And that limitation does not apply when it exercises the power of eminent domain for the purpose of acquiring public property for a public work or improvement. So public park, public road, what have you. So that's California statute. And the last topic I just want to go through is in that same Lucas case that established the per se rule, the Supreme Court also said, but hey, you know, there are background limitations on your private property rights. And if what the state or local government is doing is within those background principles, background limitations, then it's not a taking. It's just that was always a limitation on your property ownership. This exception is still being developed. Courts around the country are working through what might be a background principle, but there are three that might be particularly relevant in a managed retreat context. So first is nuisance, and I've already mentioned that in the context of counties condemning properties that are a public safety hazard. So nuisance law, no property owner can use property in the manner that constitutes a public or private nuisance. That is an unreasonable interference with public or private rights. And so those public rights, if you've got a public nuisance, states and local governments can remove a public nuisance without triggering compensation requirement. So that's a big one. Public necessity has not been developed as much, although I have predicted repeatedly it's going to become more important with climate change. But public necessity is a doctrine that was used a lot in the 19th and early 20th century that allowed governments to destroy private property if necessary during an emergency to help save the community. So the classic public necessity cases are we've got a fire raging through the town and we can stop it if we blow up your home, we get to blow up your home. If you've got a flood coming down the Mississippi and we need to destroy your property so we can put in the protections that'll protect the rest of the town, we get to do that. There are also some public necessity cases deriving from war efforts during the Civil War. So it's a doctrine that has a long history. It's been applied in a lot of contexts. We tend not to think about it more, but climate change and coastal flooding could be some situations, particularly during storms when you've got that ongoing emergency, that might trigger these public necessity exceptions to takings liability. And then the public trust doctrine. The public trust doctrine. California has a robust public trust doctrine. I notice we have some people here from Hawaii. Hawaii has a robust public trust doctrine. California's public trust doctrine includes ecological protection. It has been invoked as a limit on private property rights. And this could become an issue. All of that submerged land is public trust land in California. And so as king tides, storm surges, sea level rise become bigger issues, it's possible that the public trust doctrine will also become a justification for pushing people off the coast that would survive a takings challenge. So, again, all that could be used in a managed or unmanaged way. But for governments who want to think about managed retreat, it's important to know that these potentials are there. All right, and so with that, I will finish a couple minutes early, but leaving more time for questions. So thank you very much.
Thank you so much, Robin. That was a ton of awesome information. So I see that we have some questions that have already come through the chat, and I'll start with those. Oops. Can you hear me okay? I realized I had my microphone up. We'll start with those, but everybody feel free to add your questions to the chat as they come to you, and we'll get to them in order. I do see that one or two people have joined by phone, and so if there are questions from people that are calling in and maybe don't have access to the chat, you can go ahead and unmute yourself or raise your hand. I'm not sure if you have that function on the phone. So I'll start off with a question from Dave Revel, who's with Integral Consulting. Dave asked, can you clarify whether there is any coverage for erosion impacts in the NFIP?
There's coverage for damage from flooding. So that's the important aspect. Is if it's gradual erosion, usually not, but if it's erosion that occurs like during a hurricane or during a flooding event, yes, that would be part of the property damage that can be compensated.
Awesome, thank you. And Dave, if you have any follow-up questions, feel free to add those in the chat too. Okay, our second question from Natasha Kumar, who's with the City of LA, is there any conversation for the NFIP to redesign itself so that the funds can be used for rehousing people to safer locations and other things like aquaculture, marine environment restoration?
Definitely on the moving people to safer locations. That's part of why we've had a 6-year hiatus, is because as you know, Congress doesn't get through a whole lot of legislation these days, but one of the big debates for the National Flood Insurance Program is, should those proceeds be redirected, like I was suggesting, that we basically purchase the property, we're giving you money to relocate. I'm not aware of any bills that would put in ecological restoration as part of the premium and payout part. But there are certainly bills that have said that part of what FEMA has been thinking about is, are there ecological restoration efforts or green infrastructure that could help? So that's part of the debate. But like I said, Congress has gone back and forth, and there have been literally dozens of bills on what to do with the National Flood Insurance Program, and the details are very different depending on who sponsored the bill.
Awesome, thank you. Okay, we have a clarifying question next from Philip Johnson, who asks, when you refer to municipalities, does that refer to counties as well? I'm not sure when you mentioned that, so if you need clarification, Robin, we can have Philip come off mute.
Yeah, no, I usually use municipalities to refer to counties and cities, just because local government structure can vary so much from place to place. Municipalities kind of is a way of getting everybody, and who holds what kind of authority. County versus city from state to state can vary a bit. So municipalities is my way of just signaling whoever has got the authority to do some of this stuff.
Got it. Thanks for that clarification. Okay, we've got quite a few coming in. So our next question from Tamara Wallace, who's with the CSU system, asks regarding abandoning infrastructure. Are state agencies in California observed to be doing this explicitly through public documentation, or is it simply budgetary reprioritization of improvement projects? That's a great question.
I'm To the best of my knowledge, most of what's happened everywhere is simply a matter of budget. Municipalities are generally limited budget to begin with. And, third, fourth, fifth time they've repaired something, they tend to throw up their hands and say, we don't have the budget to do it. Now, that one case in California, the county of Monterey, that was a little different. It wasn't so much budget as, like I said, that ongoing discussion about how to balance managing the levee and canal system with achieving various environmental goals that people wanted to achieve. So that was a more conscious decision in the middle of a little bit of a battle for control and for deciding what the primary goal of that system should be. So that was a little bit different, but most of the time when it's just deciding we're going to do it, it's largely for budgetary reasons.
Got it. Thank you. We have a few more questions, but I want to take a moment just in case anybody doesn't have access to the chat to come off mute and or raise their hand. Just making sure. Okay, it looks like most people are using the chat, which is great. Okay, so our next question from Sydney Fishman, who's with Washington Sea Grant. She asks, regarding the slides on what managed retreat looks like, do you think there's a role for public agencies to model managed retreat? For example, retreating public infrastructure. And what is the role of modeling managed retreat prior to or in conjunction with promoting retreat of private property?
That's a great question, and I would hold out as my model the Department of Defense, which might sound like a very strange thing to say, but I think the Department of Defense of any public agency is the most acutely aware of the threat of climate change and sea level rise, and is already experiencing some loss of function, particularly at naval bases on the East Coast, and is already thinking about what to do about that. And so in Annapolis, for example, the Navy has already started to retreat, and is actually supplementing its retreat with helping the community to retreat too, in part because the Navy needs the community to retreat so it has access to what it needs access to. But it also partly just public community spirit that we're all getting inundated, we're all getting flooded out. This is part of all of our security. So if you want case examples, like I said, the Department of Defense and the Navy in particular is the people to whom I would point you. Annapolis, Navy bases in Florida, Navy bases in Louisiana, are all starting to grapple with the need to retreat. And a lot of times they invite community participation and community cooperation in that effort.
Great. And so I think you gave us some good models to look to, but I'll re-raise the second question just to get a bit more. So second part of the question is, what's the role of modeling managed retreat prior to or in conjunction with promoting retreat of private property? Do you have any thoughts on that?
Well, I think you can lead by example. The federal government also tends to have more money, and again, the Department of Defense is big on, or it has a lot of money to put toward these things. And so the model, again, it's going to depend on location. So in Florida, there's often not infrastructure behind Navy bases. Kind of depends on where they are, but some of them don't have infrastructure behind them. So they can do that just retreat to higher ground model. In other places where you have infrastructure behind, the Navy has been investing in compacting its facilities, transferring some of its facilities other places. Again, working with communities to help them compact as well. Put in some green infrastructure even. So that's kind of the model. Well, they're borrowing from several models depending again on what the local conditions actually are.
Gotcha. Thank you. Okay, so we have two questions from our Hawaii Sea Grant folks. So first is from Dolan Eversole, who asks, I was curious what the status is of California's Managed Retreat Fund. I thought it was vetoed by the governor recently, but had a chance at reintroduction. How is it funded?
I have to confess, I do not know.
Yeah.
So I can't help you with that one. If there's anyone participating who does know, I would be interested in adding to what I know about all this.
Yeah, does anybody in the room happen to have that knowledge, Phyllis? I'm looking to you if you might have that, or any other participants.
I don't know either.
Okay, yeah, I also don't.
Good question, though. I will
Uh-huh,
look.
great. Okay, then our other Hawaii Sea Grant question from Tara Owens is for buildings that are no longer habitable because it is unsafe due to erosion. You mentioned that there are abatement procedures that allow the government to condemn without compensation. Is that specific to California, or where can we learn more about that?
That's actually a general power of municipalities to be able to, and this is under the public nuisance exception to takings liability. It's a general power that most municipalities across the country have if a particularly buildings. If a building has become unsafe, people should not be in it. It's about to collapse. It poses a danger to children. There have been a couple of coastal cases where the building in the next storm was in such a state of repair that if it got hit by a wave, it was going to damage the properties behind it, and the local community condemned it in the non-eminent domain sense as a public nuisance and had it removed. So yeah, all of those circumstances have existed for a very long time. And certain coastal states, Maryland, Connecticut, are starting to realize that the front line of infrastructure might actually pose a significant danger to the lines of infrastructure behind it, and are starting to flex that condemnation authority a little bit more frequently.
Got it. Thank you. Okay, and then we have actually another Hawaii question. We have really great Hawaii representation today from Dwayne Fisher, who asks, in Hawaii, most of our resort areas are oceanfront properties. Those areas are huge contributors to employment and the economy. And in some cases, like Waikiki, there's no place to retreat to. Accordingly, retreating those properties is extremely complex, and other adaptation strategies may be more appropriate. Are there any examples that you know of across the country of retreating resort areas or implementing other adaptation strategies in these areas?
I don't know of any in the United States, but if you look at Palau, if you look at Tahiti, if you look at a lot of the South Pacific, which are dealing with existential threats from sea level rise, um, it's actually kind of cool. But a lot of the oceanfront resorts are built on stilts out over the ocean. And to me, I love going to Hawaii, and I'm actually building up a documentation of some of the erosion in resorts I like in Hawaii. But it's always struck me that you've got coral reefs to worry about, so you have to build carefully around those. But that some of those floating or stilted options are what oceanfront resorts in other tropical locations have been going to.
Yeah, thank you. The other thing that comes to mind is in Cancun, Mexico, where they've started to ensure nature-based kind of protective strategies, like they've insured their reefs. Um, and I think we might have some resources on that that we can include in the post workshop email. So that's the end of the questions that we have right now. I encourage folks to keep adding them if they have some. We've got a fair amount of time, but I want to ask Robin a question while we have a lull. We have a ton of sectors here represented today. We have academia, private, state, local, and we have a lot of different states as well. And so I'm wondering, you and your legal research, what do you need from these sectors as you're exploring and building, maybe not you necessarily, but as the legal frameworks get built, what is needed from these sectors to ensure, not necessarily retreat, but safe housing within the context of retreat?
I like you said, I think planning ahead and knowing what your own local situation is key. And that's actually what makes retreat legislation difficult, is it's hard to come up with um principles beyond plan ahead and here's some money to help that would apply universally. And so I think for the various sectors, really some of the best retreat strategies and there are examples from New Zealand in particular. Some of the best retreat strategies have just come from community gatherings, and granted, this works a little bit easier with smaller communities rather than something like Los Angeles. But nevertheless, where communities have gotten together and figured out what they want most. So, is what they want most to stay together as a community? Is what they want most is to minimize the retreat that has to be done? Is what they want most just to get somewhere safe because it's clear wherever they are is not going to be safe for very much longer. And once a community has those priorities, it's easier to figure out um, what aspects of state law might be helpfully changed, or what aspects of local law are getting in the way or might be helpfully changed. And also to start figuring out sources of funding, because that's a huge component of all of this, is funding either an adaptation strategy like stilts or floating, or green infrastructure, or funding figuring out how you're going to become more compact or move inland a little bit, or where are places to go. Do you have to negotiate can you maybe get a land swap going with federal land? Is there state public land behind you? What are the restrictions on that? So that's actually one of the legal challenges with coastal adaptation, is there's so many different situations and so many different goals that it's hard to prescribe and like anything beyond plan and fund, and maybe we will, on the extreme repetitive losses, we will incentive or tell you you're done, incentivize the moves. And so I think, like I said, the various sectors should embrace those differences. If you're invested in different locations, what can they teach each other and how are they very different, and what priorities should be focused on. So I realize that's not much of an answer, but that's the complexity of coastal adaptation. If you're in an area of California where the sea's actually retreating, life, at least on this respect, is pretty easy. If you're one of the areas that's in danger of getting wiped out or going under, you got a little more complicated problem. So
Yeah, absolutely. It makes me think of in our work on climate mobility, climate-induced human mobility, we have this starting point of what does the community need? But even that, like you said, in Los Angeles is different than in a small, the island community. How do you even define the community? Who gets a say? So it quickly becomes complicated. And I think we all have our work cut out for us.
yes. So
Yeah, great. Um, Phyllis, I see you've come off mute.
Yeah, just a word.
Huh?
Robin, when you mentioned something getting close to community values. In our AdaptLA program, as we start out to like assess vulnerability, we always ask the value proposition. What is it that you want to see your community look like? Do you want to have a coastal strand with beaches, or do you want no beaches and seawalls? Do you want t-shirt shops or hotels, or what is it that your community envisions for itself? And much like that, when we're talking about human mobility, um, it's the receiving communities as well as the communities that might be changing that really need to begin to consider their own value propositions. In other words, if we have people relocating, is it something that our community wants, needs, or is prepared for? And if we know that people are going to come, what do we want that sort of influx of people to look like within our community, and how have we planned for that? There are a couple of more comments in the chat.
if I can make one comment on that though, yeah, and you're right. The receiving communities have to be planning as well. Um, there there's pretty good evidence that various places in Michigan have been trying to tempt California companies to Michigan, not on a coastal retreat, but because Michigan has water, and California was in a severe drought. So there are some places. Vermont for a while was advertising for young professionals to come live in Vermont. So there are some places that are picking up the receiving community ball, and it's like, hey, we've got everything. We lost people. We could take you, no problem. So yeah, that is starting to happen too.
Yeah, absolutely. It's a lot of change will be seen, certainly. And yeah, even if you're not directly on the coast in regards to adapting to coastal change. We have a response from Charles about the question that we had previously about the funding mechanism for managed retreat in California. So I'm going to invite Charles really quickly to just come off mute and say a bit more about that.
Thanks, Karina. Can you hear me okay?
Mm-hmm.
Great presentation, Robin. Really appreciate it.
Thank you.
I was just gonna, in response to the question about the managed retreat fund, I pointed out that that's been vetoed twice now in California. The bills changed a little bit, but they basically contemplated a revolving loan program that would be funded by state appropriations. So these would be state-funded low-interest loans to local communities to identify and purchase high-risk properties, and then potentially lease back the properties to regain that loan payments that were required until such time as the properties could be removed as no longer viable. So, an interesting idea. It had great traction in the legislature, but Governor Newsom was not interested, ostensibly because of the lack of sufficient planning so far to identify where those targeted areas might be.
Gotcha. Great. Thank you, Charles. And there's a comment in response to Charles's comment about funding being via appropriation, which is part of the reason why it was vetoed. And there's a link in there to what it looks like to learn more about that. I don't know, Dave, if you wanted to add anything else to that.
I don't really have anything else to add.
Okay,
Thank
great.
you.
Thanks. Thank you. Thanks for that link as well. Okay, we have a few more minutes for Q&A, so I'm going to move to one that's just come in from Philip Johnson. The question is, with regard to background principles, when a public nuisance or public necessity is declared, is compensation not required? Is this uncertain legal ground?
No, that's certain legal ground. If it's a public nuisance or a public necessity, compensation is not required. Now, in a lot of the public necessity cases, state legislatures after the fact would go and provide a little bit of compensation, just as kind of a soothing feelings, politically expedient thing to do. But legally, no. And that's why they're background principles, is you do not have the right to be a public nuisance, and public necessity can override private property rights without compensation.
Great, thank you. Okay, I want to open the door for another minute or two if anybody has any other questions. At this point, we're a bit ahead of schedule, so if you'd prefer to come off mute to ask your question, feel free to do that. Tara from Hawaii Sea Grant asked if you'll receive slides and recording. Definitely the recording. Robin, are you okay sharing your slides?
I am okay sharing my slides. I will just note that they are SlideGo slides, so the Creative Commons license requires that the last two slides remain in whatever further use you put to them. So
Great. I'll make sure to include that note in the email too, in the post-workshop email. Okay. Well, if there are any other questions that come up even after this, please feel free to reach out to our team. Any other thoughts, impressions, we'll be sending out a survey, a post-workshop survey as well, to learn how we can make programming like this even better in the future. So what I'll do now is share my screen with just a few notes on what's happening next. Oops. Let's share. Okay, can everyone see that okay? Great. So like we said, Robin put together this wonderful guidebook to coastal adaptation legal issues within the state that we'll be sharing with everybody that participated today, but also feel free to disseminate more broadly. We will be printing a lot of physical copies of this, and so if you'd like to request a physical copy, we'll include a link or a way in the post-workshop email to request that. The other thing that I want to highlight is we've also just finished putting together our People on the Move in a Changing Climate report, which was a workshop that took place in 2022, assessing the needs in the Southwest region for planning for and addressing climate-induced human mobility. And so in there we have some of the legal needs that we identified, but we also have research needs, communication needs, things like that. A lot of themes in there we touched on today in today's workshop. Otherwise, that is all we have for the presentation portion of today. If you're not already signed up for our AdaptLA mailing list or not in touch with a part of our AdaptLA network, we encourage you to sign up for that. And again, if you have any comments, ideas, questions, please don't hesitate to reach out to me